I have watched judicial authority move from deliberation into command before, not through the front door where constitutional challenges are argued over months, through the side entrance where emergency becomes standard procedure and temporary becomes the architecture itself. The Supreme Court just issued a 6-3 emergency ruling that took effect before most Americans knew the case existed. No oral arguments, no months of briefing, no traditional opinion explaining the constitutional reasoning in detail. Just a sudden order that rewrites how federal law operates across all 50 states, issued through what legal scholars call the shadow docket, a mechanism that was designed for rare crises but has become the court's preferred tool for making law without visibility. This is not the first time. It is not even unusual anymore. But this particular ruling reveals something that the traditional court process was designed to prevent: the ability of 6 justices to restructure legal reality overnight, binding hundreds of millions of people to interpretations of constitutional law that were never subjected to the scrutiny that supposedly defines American judicial process. The public understands the Supreme Court through a specific image: 9 justices in robes, lawyers presenting arguments, months of deliberation, lengthy written opinions explaining every constitutional principle at stake. A process designed to be slow, transparent, and reversible only through equally deliberate means. That is the Supreme Court of Civics textbooks and historical cases that get taught in law schools. That is not the Supreme Court that issued this emergency ruling. What the court used is called the shadow docket, a procedural mechanism that allows the justices to issue binding orders on an expedited basis without the traditional safeguards. The term itself only entered common usage in the last 5 years, but the practice has been accelerating. In 2025 alone, the Supreme Court issued 71 shadow docket orders that affected substantive legal questions. That is more than double the number issued in any single year during the previous decade. The case that just produced this 6-3 emergency ruling began less than 90 days ago. A federal policy was challenged in a district court. The district court issued a preliminary injunction blocking the policy. The government appealed to a circuit court, which upheld the block. Then the government filed an emergency application directly with the Supreme Court, asking the justices to stay the lower court's injunction and allow the policy to take effect immediately while appeals continue. The Supreme Court granted that application. 6 justices voted to overturn the lower courts and allow the policy to proceed. 3 justices dissented. The majority issued a brief, unsigned order, fewer than 3 pages, with limited explanation of the constitutional reasoning. The dissent was longer than the majority opinion, and within hours, the policy that 2 lower courts had found constitutionally problematic was being enforced nationwide. This is how emergency procedure has replaced constitutional process, not through a formal change in the law, through the normalization of shortcuts that were supposed to be used only when delay would cause irreparable harm. The 6-3 split is not random. It reflects the ideological composition of the court with near-perfect consistency. The 6 justices in the majority are the same 6 who form the conservative supermajority in nearly every contentious case. The 3 dissenters are the court's 3 liberals. This alignment has held across dozens of shadow docket rulings over the past 18 months. What that means in practice is that the court's conservative majority has discovered they can advance their constitutional vision without submitting it to the slower, more visible process that allows public scrutiny and institutional pushback. They can simply grant emergency applications that align with their preferred outcomes, issue brief, unexplained orders, and the policy takes effect immediately. By the time anyone could challenge the reasoning, the facts on the ground have already changed. According to early indicators from legal analysts tracking shadow docket patterns, approximately 67% of emergency applications filed by the current administration have been granted by the Supreme Court in 2025. During the previous administration, when that figure was 34%, the court is not applying a neutral standard for what constitutes an emergency. It is selectively deploying emergency procedure based on which policies it wants to see implemented immediately. The policy at the center of this particular ruling affects how federal agencies enforce regulations across multiple sectors. The exact details vary depending on which version of the government's briefs you read, but the structural impact is clear. Federal agencies now have broader discretion to act without waiting for judicial review to conclude. They can implement contested policies, collect data, enforce compliance, and impose penalties, while lawsuits challenging those policies are still working through lower courts. And if the Supreme Court has signaled through this emergency ruling that it will overturn lower court injunctions that block such policies, then lower court judges now know that issuing those injunctions is pointless. The Supreme Court will simply reverse them on the shadow docket without full briefing or argument. This creates a chilling effect that operates even in cases where no emergency application has been filed yet. Judges begin ruling with one eye on how the Supreme Court's majority will respond if the government appeals. This is judicial power operating as preemptive compliance. The emergency ruling does not just decide one case. It signals how dozens of future cases will be decided before they are even filed. Within 48 hours of this ruling being issued, federal agencies in at least 4 departments began accelerating enforcement actions that had been paused pending litigation. They did not wait for the underlying appeals to conclude. They read the emergency order as authorization to proceed immediately. The Department of Justice sent internal guidance to U.S. attorneys' offices across 94 districts, instructing them to move forward with cases that had been held in abeyance. The reasoning was explicit. If the Supreme Court has lifted the injunction, enforcement can resume. But the Supreme Court did not rule on the merits of whether the policy is constitutional. It only ruled that the policy can be enforced while the case continues. In theory, the lower courts could still find the policy unconstitutional after full briefing and trial. In practice, once a policy has been implemented nationwide for months or years, courts become reluctant to unwind it. The emergency ruling effectively decides the case by making reversal practically impossible. State governments are facing the same calculation. 17 states had filed briefs opposing the federal policy and supporting the lower court injunctions. Those 17 states are now being forced to comply with a policy they argued was unlawful, based on a 3-page order issued without oral argument. Their state attorneys general have begun advising agencies to implement compliance protocols, even while they continue appealing the underlying case. The number of people directly affected by this single emergency ruling is difficult to calculate with precision, because the policy touches multiple enforcement systems. But according to draft assessments from government accountability organizations, the immediate impact includes at least 4.3 million individuals who interact with the relevant federal programs annually, and approximately 180,000 businesses that must adjust compliance procedures within 60 days. Those businesses are not receiving guidance from final court decisions. They are adjusting based on an emergency order that could theoretically be reversed if the full case is ever decided differently. But the costs of adjusting, then readjusting, then adjusting again are high enough that most simply comply with whatever the current emergency ruling requires and absorb the expense as a cost of operating under legal uncertainty. This is governance through procedural chaos, where the law is whatever the Supreme Court's majority said it was in their most recent emergency order, regardless of whether that order will survive full constitutional scrutiny. Lower courts are paralyzed. Between this ruling and 3 similar shadow docket orders issued in the previous 6 months, district judges now understand that blocking federal enforcement through preliminary injunctions will likely be overturned on emergency appeal. The Supreme Court has effectively removed one of the primary tools judges use to protect constitutional rights during litigation. You can still file a lawsuit. You can still argue the government is violating the Constitution, but you cannot stop the violation while your case proceeds. The government can implement the policy, collect your data, impose the penalty, and enforce compliance. And if you eventually win your case 3 years later, the remedy is monetary damages, not an injunction that prevents the violation in the first place. For constitutional rights that involve privacy, speech, or freedom from unreasonable searches, damages do not restore what was taken. The violation is permanent even if the court eventually calls it unlawful. This emergency ruling also sets a precedent that will be cited in dozens of future cases that have nothing to do with the specific policy at issue here. The reasoning the majority used, limited though it was in the 3-page order, establishes principles about judicial deference to executive agencies, the standard for granting emergency stays, and the scope of preliminary injunctions. Those principles will now be applied by lower courts across the country in cases involving entirely different legal questions. A ruling issued without full briefing or oral argument is now binding precedent that will shape constitutional law for years. And because it was issued on the shadow docket, there is no detailed opinion for lawyers to parse, no concurring opinions to clarify ambiguities, no dissent that maps out alternative reasoning. Just a short order and 3 votes that will be interpreted and reinterpreted across thousands of future cases. If the current trajectory holds, the Supreme Court is shifting from being the institution that resolves legal uncertainty after careful deliberation to being the institution that creates legal certainty through rapid command. The shadow docket is not a temporary expedient. It is becoming the primary mechanism through which the court's majority implements its constitutional vision. The 3 dissenting justices wrote separately to warn about exactly this pattern. Justice Sotomayor noted that the majority's use of the shadow docket has increased by over 200% since 2020. Justice Kagan pointed out that the court is now deciding momentous constitutional questions in late-night orders without the benefit of lower court fact-finding or adversarial briefing. Justice Jackson described the practice as government by judicial fiat, where emergency becomes normal and speed replaces reason. But dissents do not change outcomes. They document objections that will be read by historians trying to understand how judicial process was replaced by procedural shortcuts that no one voted to authorize. The case that produced this emergency ruling will technically continue through the lower courts. There will be more briefs. There may be a trial. There could eventually be a full Supreme Court opinion if the case is appealed again after final judgment. But by then, the policy will have been in effect for years. The compliance systems will be entrenched. The data will have been collected. The enforcement actions will be complete. And courts will face the reality that reversing the policy at that point would cause the very disruption they were trying to avoid. This is how temporary authorizations become permanent realities. Not because anyone planned it that way, because the procedural shortcuts designed for emergencies create facts on the ground that make reversal impractical. I am not predicting what comes next. I am documenting the moment the process changed. The Supreme Court's 6-3 majority has discovered they do not need to wait for cases to work through the traditional system. They can simply grant emergency applications, issue brief orders, and reshape constitutional law without the visibility and accountability that the judicial process was designed to provide. And the millions of Americans affected by these rulings will not know their rights were redefined until they receive a notice of enforcement action based on a 3-page order they never saw, issued by a court that never heard argument in a case they were never party to. The emergency is not the crisis the government claims justifies these rulings. The emergency is the procedure itself becoming the system.